Okay, cool. Good morning, everybody. I think that we have gone live this morning on our workplace law update. If you are based in Hawke's Bay with us, you'll have some pretty sunny weather after a cloudy start. Otherwise, from around the rest of the country, hello, good morning and welcome. I'm Miriam Mitchell, partner here at Ashcroft Mitchell McGregor, and I'm co-presenting today with our Auckland partner, Shush, who will give you an excellent update on what's new in the immigration space. If you just want to say hi, Shush, anything you want to say by way of introduction at the start?
Just hello, everyone. Thanks for joining us today. Back to you, Miriam.
Great, thank you. So I will be covering off some employment updates and health and safety updates at the start, and then Shush will take over towards the end, cover some immigration updates, and then we have saved time for questions. So please think about your questions as you go. If there is anything that you are dying to ask us, there is the chat and the Q&A function at the top. So if you press open Q&A and pop in your questions in there, we will do our best to either deal with them as we go or at the end. So we will get underway so that we've got time for that questions, or those questions. As most of you will be familiar with who we are at AMM, or Ashcroft Mitchell McGregor. We're specialist employment lawyers, health and safety and immigration, so we can assist you with all matters across those subject areas, going from compliance right through to the nitty-gritty when you've got a complaint or an issue with immigration or WorkSafe and representation in that space. So today we're going to give you one real brief slide to recap what the changes were in the employment space earlier this year. Then we will cover what the new proposed health and safety reforms are, and the employment leave bill and how things are going to change in that space before I hand over to Shush to cover changes to the skilled migrant categories, 2 new pathways, some additional immigration changes that he'll talk to you about, and changes in relation to the deportation liability and areas where we're seeing employers falling short with compliance. So that's roughly the outline for today, so we'll get on with it. You will probably have heard, and I know some of you will have been in our update from earlier this year, that there's been quite a lot going on in the employment law world this year, and the government is trying to sort of ramp things up and get through a bunch of changes that have been on their to-do list before we've got the election later this year. So what have we seen already this year? We've already seen employer contributions increased to 3.5% in relation to KiwiSaver, and we had the Employment Relations Amendment Act come into force earlier this year that brought in place a raft of changes in relation to contractors, new rules about who counts as a contractor. We refer to that as the contractor gateway test. A bunch of changes around the rules on remedies. So, for example, employees who have contributed to the situation giving rise to their grievance will have reduced remedies, and those employees who have committed serious misconduct won't have access to remedies. So we're starting to see some real interesting changes in the case law in respect of that, and different dynamics on how advocates are engaging in disciplinary processes. On that, we've already seen, for example, a recent case where there has been a restructure. The employee challenged that as not being a genuine restructure, but and the ERA found, yeah, correct, there were some issues with the restructure, but reduced the remedies to the employee because they didn't engage with that process in the consultation period, and didn't give a feedback to the employer along the lines of what they were complaining about at the authority. So their remedies were reduced. So we're starting to see how these new rules are starting to play out. You will have heard, hopefully, that there is a limit on the unjustified claims for high earners. So those employees who earn over 200K, if they're dismissed, won't be able to bring a personal grievance. That's already in play for new employees since the beginning of the year, and comes into force for existing employees towards the end of at the beginning of next year. So you'll need to engage with your employees on that to ensure that you've addressed that in your employment agreements and come to some kind of arrangement with existing employees. And we saw the end of the 30-day rule for unionised employers and some changes in relation to the Privacy Act that essentially said, look, if you're going to collect information from a third party, then you need to let that person know that you've collected that information. So we covered all of that earlier in the year in more detail. If anybody needs our slides in respect to that, please feel free to sing out and ask, or if you need any further support in respect of that, you know where to find us. Otherwise, what we really wanted to focus on today are health and safety changes, because they're now in law and come into force next year. And then we'll also talk about the up and coming proposed changes in relation to leave. So the Health and Safety at Work Act, the government has been reviewing that for some time and announced reforms to that back in April last year. The Minister has been up and down the country and has engaged with employers in respect of that and a number of industry bodies and got some pretty mixed feedback in terms of what has been proposed. Went to select committee, and very recently the proposed changes have been passed into law under the Health and Safety at Work Amendment Act, and those changes will come into force on the 1st of April 2027. The aims of these changes are to seek to reduce compliance burdens, especially on smaller employers, clarify health and safety duties in respect of those organisations that have got overlapping duties with other organisations, and also in respect of due diligence obligations for those government's roles, and refocus the sort of structure of health and safety on serious harm, as opposed to having necessarily to look at all hazards across an organisation. So that's broadly speaking what the changes are aimed to address, and we'll go through some of those changes on this slide. And just a reminder, any questions on this, feel free to pop this up in your Q&A using the Q&A button above. So health and safety reform, there's a number of changes, including limiting the obligations for small, low-risk businesses to managing only critical risks and providing basic workplace facilities. So if you are an employer with fewer than 20 workers, so 19 or less people within the workplace, rather than having to have a risk register that covers all hazards within the organisation and then putting in place controls to manage those, what you will need to do as a bare minimum at least is have identified your critical risks and have in place a management plan for those, and provide basic workplace facilities. They, at the same time, have tweaked the definition of what a critical risk is. Essentially, it is either of a number of things. The first being a hazard that is described in the new Schedule 1A to the Act. So there's a schedule at the end of the Act, has a big long list of what is a critical risk. Essentially, that applies to industries such as asbestos mining, remote or isolated workers. It's those industries that are governed by high risk regulatory regimes. So your normal retailer, for instance, wouldn't be identified in Schedule A. That's the first category of a critical risk. Second is it's otherwise any other hazard likely to result in death, a notifiable injury or illness, or a notifiable incident. And hopefully you'll be familiar with this language, because this is all carried along from the old Act in terms of what is a notifiable injury, illness, and a notifiable incident. But otherwise, it can also be an occupational disease that's listed in the accident compensation legislation. So that is a definition of a critical risk. The main thing to note about that is while the definition of critical risk itself does not refer to mental harm or health it can encapsulate that. So what hasn't changed under the Health and Safety at Work regime is the definition of health within the Act, which says that health means both physical and mental health. And the Select Committee specifically turned its mind to that. There was a bunch of submissions seeking clarification as to whether the Act will continue to apply to mental health. And the Select Committee's answer in short was, well, the Act already does, and the way in which it does hasn't changed, so yes, it will continue to do so. That means, for example, if there are certain situations that may result in such significant mental harm to an employee that they may contemplate suicide or have extreme PTSD, type injuries as a result, then they'll fall within that definition of critical risk. So in addition to seeking to ring fence health and safety management to critical risks for smaller businesses, the Act as a whole sort of seeks to focus in on serious risks. It also seeks to streamline compliance between health and safety and other regulatory systems. This will really only affect those businesses that have some specific other regulations that apply. So, for example, where there is a comparable obligation under another regulation or act that applies to the industry, then compliance with that will almost deem compliance under the Health and Safety at Work regime. Otherwise, there are also changes in redefining the cooperation between PCBUs with the same duty. This was brought in really to give some clarity around, well, how do smaller businesses then interact with larger businesses in relation to the types of risks that need to be managed? So, for example, under the old regime, all PCBUs had an obligation to take reasonably practical steps to manage health and safety within the workplace. And then there was also these provisions in relation to overlapping duties, where if you've got a bunch of subcontractors on the same site, they had to coordinate and consult and cooperate with each other in respect of that. Now we've got this regime where if you're a small business, you only have to turn your mind to the critical risks, but if you're a large business, you of course still need to do the wider risk assessment. And so there is now some clarifications in relation to, well, how do those PCBUs cooperate with each other? So at the Select Committee stage, provisions requiring cooperation between PCBUs who have a duty in relation to the same matter were inserted. And the effect of those, broadly speaking, is that the small PCBUs must cooperate with all other PCBUs in relation to any critical risk, and they may cooperate in relation to all large risks. Now, large PCBUs must cooperate in relation to all risks so far as reasonably practicable, and cooperate means consulting, coordinating activities, and it's an offence to contravene those cooperation provisions with specific penalties applying in relation to that. So it sets up really, I guess, like a minimum bar. Small businesses must cooperate and deal with critical risks and engage with others on work sites in relation to those. Larger organisations must cooperate in relation to all risks. Of course, how that plays out in practice will remain to be seen. Wouldn't be surprised whether from a contractual compliance perspective, those larger organisations will be seeking to insert as a contractual obligation, that obligation to cooperate in relation to all risks. So whether that results in any practical changes for smaller businesses will remain to be seen. Otherwise, other changes in the Act relate to notification requirements to WorkSafe, to apply only to significant workplace events, and there's some specific rules around that. There is some adjustments to governance and operational responsibilities to clarify those due diligence obligations, and to clarify for officers that when they're working in specifically a governance and a worker role, that their governance role really only applies in relation to the governance work that they do. So really important for organisations to document very carefully as to whose role is what. There's been some reform in relation to ACOPs, or approved codes of practice. Really, they've been sort of given more emphasis in the Act, and the new regime seeks to have greater industry involvement in developing approved codes of practice, and sets up a regime that whereby essentially if you're following the approved code of practice, then that will provide stronger assurance of compliance with your health and safety obligations. So that very broadly are the up and coming changes under the health and safety reform, which will be enforced from the 1st of April next year. So turning away from health and safety reform, just getting my slides up to speed, let's talk about the Employment Leave Bill. So again, some quite significant changes. This is not yet new law. This is still what's being proposed. We're anticipating, however, that the government will want this to be having been passed into law, even if it doesn't come into effect until a couple of years' time, by the time that the election rolls round. So we have only just seen a select committee report on the bill. It was published on 13th of July. It doesn't seek to change the bill too much, so probably downhill run from here for the government to get over this, get this over the line as new legislation. So by way of background, the Employment Leave Bill sets to replace the entirety of the Holidays Act 2003. We've all known, we don't need to hear the policy statement, but for all of us that have worked in this area, we all know the headaches that the Holidays Act has created. And so the government has sought to address that, and there'll be a 2-year transition period once this new regime has come into law to allow time to adapt to the new regime, unless you're a school and those sectors are being given a 10-year lead-in. So what's changing? A bunch of stuff, really. You'll all know under our current Holidays Act that holidays accrue in weeks and sick leave accrue in days. And what all of that is changing, and sick leave and both annual leave will be accrued by way of hours. So sick leave, the main changes are that leave will now accrue from the employee's first day of work, and it will accrue at a minimum rate of 0.0385 hours per standard hour of work. So it would be really important to have an understanding as to what are standard hours within your employment agreements and work arrangements with your employees. And there will be a proposed cap to sick leave of 160 hours. That's equivalent to the current regime of the 10 days a year for a standard working week. And sick leave will be taken in hours as against standard hours, as opposed to days. Yeah, that's the main changes in relation to sick leave. Bereavement leave and family violence leave remain day-based entitlements, but again, they'll arise from the employee's first day of employment rather than having to wait for that 6-month period. All right, what is next? I think I have skipped a slide here, so let me go back a little bit to cover annual leave, because this is important, of course. So again, same as sick leave, annual leave under the new regime, if it's passed, will accrue from the employee's first day of work. It will accrue at a minimum rate of 0.769 hours per standard hour. And annual leave will also accrue during periods of paid statutory leave, parental leave, volunteer leave, and jury service. but it will no longer accrue while an employee is receiving compensation from ACC. So certainly heard a lot of positive feedback from a number of employers in relation to that change. So if you've got an employee who's off for months on end on ACC and you're waiting for them to recover and come back, they will, under the new regime, no longer be accruing annual leave during that period. Right, let's move on. So there will also be changes as to how annual leave and sick leave is accrued for employees who are on casual hours. So there will be a new leave compensation scheme, new leave compensation payment, introduced, which will be a set rate of 12.5% of an employee's ordinarily hourly rate that will be paid on all additional casual hours worked instead of accruing annual and sick leave. So essentially how the regime is going to work is people will have their standard hours. Say somebody's standard hours are 40 hours per week. They will accrue sick leave and annual leave on the rates just set out in the previous slides. If they do any additional hours in relation to their standard hours, they won't accrue more leave, but they'll be paid a rate of 12.5% on their hourly rate for those additional hours to account for annual leave and sick leave for those additional hours. Or otherwise, if you're a casual worker, you won't be accruing leave, you'll just be paid that 12.5%. So that's broadly speaking how that regime will work. There will also be the introduction of a new definition for an otherwise working day. I know there's been a number of employers, particularly where they've got employees with variable working patterns as opposed to fixed ones, where it's hard to determine, come a public holiday, whether they should get paid for that or not. Is it an otherwise working day? Under the new regime, the test will be, it will be a otherwise working day if the employee has worked or was on paid or unpaid leave for 50% or more of the same day of that week as the public holiday in the preceding 13 weeks. So, for example, we just had Matariki fell on a Friday. We had a few clients that were saying to us, well, we've got this employee with variable working patterns. Sometimes they work on a Friday, sometimes they don't. Do we treat that as that being an otherwise working day for the employee? Under the new regime, you'll look at the last 13 weeks and did they work more than half of those Fridays in the last 13 weeks? If yes, that is an otherwise working day. If no, then no, it's not. So much clearer cutoffs in respect of that. Now I'm just looking up at the Q&A section and I see that no one's popped anything up in respect of that yet, no posts. So please be thinking of your questions as you go along. There is that opportunity to ask questions in this session and have anything that you didn't understand that we've just covered or maybe haven't covered, clarified. It's your opportunity to tap into the resources that you've got here today. So that is, broadly speaking, the new legislative changes that are coming up. Health and Safety at Work Act definitely comes into force from the 1st of April. The new leave regime, still not yet in law. We're anticipating it will be passed before the government leaves. Well, we don't know whether they leave, do we? Before the election, I should say. They'll definitely want the legislation, that the new leave provisions in the legislation before the election, and then we're waiting yet to hear as to what the proposed enforcement date for that is, but then there'll be this 2-year window for employers to comply. So that's the new pieces of law. What are some of the recent cases that we've been seeing? I'm going to cover 2 before I hand over to Shush on this immigration stuff. The first case is called Manawatu Motors versus Renner. So this is a case that came before the Employment Court as a de novo challenge to an earlier authority decision. And back at the authority level, both parties were originally found to have breached their obligations in respect of the employment agreement and each other, and so no remedies were awarded. But that was appealed or up to the Employment Court. By way of background, the employee, Mr. Renner, he was a long-serving sales manager at Robertson Isuzu in Palmerston North, and a key part of his role was managing the company's exclusive New Zealand distribution relationship with Shin Meiwa, a Japanese manufacturer. So while still employed, Mr. Renner began preparing for his departure as he was moving on from the company, and this really went beyond mere planning in this particular situation. He actively started facilitating introductions between Robertson's Isuzu customers and Shin Meiwa. He provided a competitor with Shin Meiwa's contact details. He raised concerns with Shin Meiwa about Robertson Isuzu's ability to maintain the relationship after he left. He negotiated a potential 200k sign-on bonus with a competitor linked to bringing Robertson Isuzu's customers across. So bunch of stuff there that he was doing actively, really, to undermine the relationship that Robertson's Isuzu had there. Shortly after his resignation in July 2023, Shin Meiwa indicated it was moving away from the exclusive arrangement and signalling that its relationship with Robertson's Isuzu had been destabilised. So although Mr. Renner's contract contained a restraint of trade clause, it was incomplete, unfortunately, not well drafted, and therefore unenforceable, leaving the employer without a bunch of additional protections that could otherwise have been available to it. Now, despite that, the Robertson's Isuzu claimed that Mr. Renner had breached his common law duties of fidelity and good faith. And these are duties that require employees to act in the employer's best interest while they're still employed. So regardless of what an employment agreement says, there is a bunch of duties that both employees and employers owe, either by way of what's in the Employment Relations Act or by way of what we call common law. Basically, that's to say, whatever there are some duties that the cases over time have said that employees and employers owe to each other. And in this particular instance, the employer sought to rely on those duties, being the duties of fidelity and good faith, and sought to make a claim that the employee had breached those, that they had suffered losses as a result and should be awarded some damages. In response, Mr. Renner brought a counterclaim. He argued that his commission throughout his employment had been paid incorrectly or had been incorrectly calculated, and that he hadn't been paid his full entitlements in respect of that. So off to the Employment Court they went. And the court found that Mr. Renner had breached both his common law duties, both the duties of fidelity and good faith, and his the express terms of his employment agreement. Importantly, the court clarified the boundary between lawful preparation and unlawful conduct. So there's a difference between preparing to leave and then breaching your duties that you owe to your employer while you're still employed with them, even if you're planning on leaving. So the court said that while employees are entitled to make plans to compete and are not required to disclose those plans, they must not take steps that harm the employer's business, the relationships or reputation while they're still employed. And the Employment Court found that in this instance, Mr. Renner had crossed that line. It said he acted as a conduit between Robertson's Isuzu customers and Shin Meiwa and actively undermined the employer's relationship with the key supplier by raising doubts about its future capability. And the court found that this conduct was a substantial factor in causing Shinmeiwa to move away from the exclusive relationship and encouraging customers to deal directly with Shinmeiwa. So the court also reinformed the causation test. It's one thing, right, to find that an employee had maybe crossed that line. The next question that the courts will always look at is, well, was that the cause of the loss? Was it but for Rena's actions that Robertson's Isuzu suffered the losses that they say they claimed? So the court said where an employee's breach is a substantive factor in causing loss, then that would be sufficient to establish liability. And here the court was satisfied that Mr. Rena's actions had caused Robertson's Isuzu's loss and not some other outside factor, for instance. So some quite big remedies awarded here. In assessing the damages, the court adopted a loss of chance approach. It's recognised that not all of the loss was attributable to Mr. Rena, as some competition after his departure would have been legitimate, and the court therefore applied a discount to reflect that uncertainty. But ultimately, damages of 900k were awarded, which is just over 40% of the lowest loss that was estimated or presented by Robertson's, plus interest. And so the court considered this discount to be reasonable in light of the mixed causes of losses. So quite an interesting case that we see here. So I'll move on to the next one. Key takeaways in this case is that this case really highlights the risk of relying heavily on a single employee to manage critical commercial relationships, and particularly when you're doing that without a properly drafted and enforceable restraint of trade clause, then employers can be exposed when that employee departs. For senior employees, for employees that hold close relationships, particularly ones that have great worth, such as the Shinmeiwa ones, those template agreements are not enough. Key bespoke clauses really must be tailored to the situation to ensure that they are enforceable before signing. The case also reinforces that duties of fidelity and good faith continue right up to the end of employment. And while employees can quietly prepare or leave or compete, they mustn't take active steps that damage the employer's business or relationships. And just as a keynote, there's an example as to why it's really important to have great and well-drafted employment agreements. Had their those duties of fidelity and good faith been specifically drafted into the employment agreement, the employer would have been able to access a breach of contract claim as well as just relying on those common law duties. And finally, the case is a strong reminder of the potential for financial consequences. So when an employee crosses the line, then damages exposure can be significant, as demonstrated in this particular case. Right, I've got one final case before I hand over to Shush. I will just cover this one briefly. Main reason being it's been appealed and it's been heard by the Court of Appeal, and we're currently waiting for a decision in respect of that. But the key facts of this case is this is Soapy and Pick Hawke's Bay. This is a case where Pick Hawke's Bay had recruited overseas seasonal Pacific workers under an RSE scheme. And while that is quite unique, and I know that many of our clients don't use RSE workers, a number of the principles that have come out in this case are applicable nevertheless, so I will cover those off. Now, these RSE workers had an arrangement with their employer whereby they'd come on site, they would get paid their wages, but then there would be a number of deductions from their wages for things like their accommodation, at times for their PPE and other bits and pieces. They then made a claim to the employment court to say that the deductions were unlawful, essentially. And then there were a bunch of principles that came out as a result. The main ones to note are if you're going to make deductions from an employee's wages, then you need to ensure that you have either a lawful deductions clause in your employment agreement or some separate express consent that's signed by the employee in respect of those deductions. If the deductions relate to accommodation, there are some specific rules about stating the cash value of that accommodation in the agreement. Otherwise, you can't deduct more than 5% of the accommodation cap. There are some specific rules in the Minimum Wage Act and the Wages Protection Act that were highlighted by this case, and the main one being that the Employment Court found here that the workers were not receiving minimum wage in their wage pack anymore by the time that the deductions had been made, and therefore the deductions were unlawful. So if you have employees who are at that minimum wage threshold and you need to make deductions from their wages, from say training or any other thing that you have agreed with that employee that you will make deductions from their wages in respect of, then they still need to receive minimum wage in their pay packet after those deductions have been made. Now that specific piece has been appealed to the to the Court of Appeal, and we're waiting to hear what they will say on that. Otherwise, also note deductions for PPE can't be made because it's the employer's obligation to provide those. A bunch of remedies were awarded to the employees in this instance on the back of the finding that the deductions were unlawful. And so it's just a reminder of the exposure for employers of getting these things wrong. So key takeaways for employers are that wage deductions must be lawful, reasonable and consented to in writing and must not result in the employee receiving less than a minimum wage. You'll need to find other workarounds. So for example, you could pay the employee their wages and then have them set up an automatic payment or invoice them to get that money back. It seems a little circular, doesn't make sense, and hopefully the Court of Appeal will change that, but that's the current law for now. REC deductions from wages must of course be approved by Immigration New Zealand, and there's some specific rules around deductions for accommodation, so ensure you're complying with those. And it's always good practice, of course, to document the deductions and conduct regular compliance reviews internally to ensure that you're getting that right. And of course, we can assist with any deductions that you need to make and review any deductions clauses if that is of help. So I'm going to hand over to Shush now.
Cool, thanks Miriam. So just to recap, today I'll be providing some information on the skilled migrant category changes. Secondly, I'll be providing some changes in regards to deportation liability. And lastly, we'll cover sort of areas where we see employers sort of fall short, including around infringement offences. So first starting with the skilled migrant changes, but before we move into that, I'll just have some comments on the maximum continuous period of stay. So in essence, unlike the old immigration policy where essential skills work visas were around, under the accredited employer work visa category, there is a maximum period of stay. And what that means generally for most workers is that they can only be in New Zealand for 5 years on an accredited employer work visa. And then if they can't apply for residence within that period, and immigration sort of indicated there might be a short extension of 6 to 12 months for people who are already on a pathway to residence. If they can't in essence, apply for residence and obtain residence within that period, they'll need to depart New Zealand for 12 months continuously before they can meet requirements for a further accredited employer work visa. Now, for some of the migrant workers who are on skill level 4 to 5 roles, there is a shorter maximum period of stay, period of 3 years, and there are some exceptions here which I've listed out, but I won't cover that in detail. But what I'll do is I'll just go straight to the takeaway and the relevance of this information. In essence, the relevance of this as skilled migrant changes are that at a high helicopter level, the government identified that under the sort of current 6-point skilled migrant pathway, where migrant workers need a bachelor's qualification, they need to be paid at least 1.5x median wage rate, or they need to work in a role that has occupational registration. They found that the threshold for residence was potentially too high. So in essence, what has happened with these new skilled migrant changes is two pathways have been introduced to, in essence, lower the threshold for for migrant workers that can't meet requirements. And a part of that fits in with the maximum period of stay, because for a lot of these workers, especially the ones who were supported for AEWVs in 2022 and 2023, their maximum period of stay will probably trigger from next year onwards. So it's quite handy that the government have introduced these changes to the skilled migrant category. Miriam, could you move us to the next slide, please? So in essence, there are two new pathways under the current skilled migrant category that are being introduced. Just when considering this information, it's important to understand that the existing framework will still be around. So what that means is, let's say you've got a worker and they've got a bachelor's qualification, and they're already on a pathway to residence, working 3 years. Or trying to obtain 3 years of skilled work experience, that pathway to residence will still be there for the worker. It's not like that's being taken away. It's just there are two new additional options for migrant workers to consider if they wish to use the new pathways. And the first new pathway is the trades and technicians pathway. That's for certain trade and technical roles. It will require workers to have a level 4 qualification. And the second pathway is the skilled work experience pathway. That pathway is for migrant workers with strong work experience. We'll cover some more detailed information on each of these pathways in the later slides. For the current skilled migrant 6-point path category, and also these two additional pathways, additional eligibility criteria will apply, and that includes meeting the English language requirements, health and character requirements, and along with other standard visa bona fide requirements, along with the requirement for employers to remain accredited and have good general standing with Immigration New Zealand. With the two new pathways, there will be an amber and red list that will be introduced. These only technically apply to the skilled work experience pathway, and I'll cover this in more detail later. Miriam, could you move us to the next slide, please? So here is some information on the trades and technician pathway. In essence, to qualify under this pathway, migrant workers will need to work in a role that is in essence listed as a trade and technicians pathway role, and I'll have this on the next slide, but we won't move to that yet. In addition, they'll need to have at least a level 4 qualification. The qualification will need to be relevant to the role that they'll be working in, and if that qualification is gained in New Zealand, it must be of at least 120 credits. If it's gained offshore, the worker will need an NZQA IQA. The credit requirement doesn't apply for offshore level 4s. In addition to having the right role and being paid the skilled median wage rate and the qualification, migrant workers also need at least 4 years of directly relevant work experience that's gained after their level 4 qualification was obtained. Just things to note here that might catch migrant workers that are looking to utilize this category out. Firstly, self-employment work experience doesn't count towards this category. So for example, technicians who were self-employed, they won't be able to use that pathway, or they won't be able to use that work experience. Second, the work experience, directly relevant work experience, has to be gained after a qualification has been completed. So for example, if there's directly relevant work experience gained before the qualification was completed, that can't be counted as well. And migrant workers could get stuck with that. The good thing about this pathway, though, is migrant workers only need to be paid the skilled median wage rate. There isn't a requirement to work with a high multiplier of 1.1x, for example. Miriam, could you please move us to the next slide? Here I've sort of just consolidated, dated, and put together a list of all the roles under this pathway. So one of the key requirements is that to be able to apply for residence under this category, the role has to be listed under the trades and technicians roles list, and it's quite there's no workaround here. If the role isn't listed here, the migrant workers wouldn't be able to use this pathway for residence. So just to it's an important takeaway just to keep that in mind, that if a role isn't listed here and someone's trying to apply for residence under this category, there is a risk that they won't be able to meet a really key requirement, which is that their role needs to be listed under the trade and technicians pathway to be able to utilize this this pathway for residence. Miriam, could you please help move to the next slide? So the second new pathway that's being introduced is a skilled work experience pathway. Now, under this pathway, migrant workers just need to be working in a skill level 1 to 3 role. Now, with the pay rate, though, this needs to be at an increased rate of 1.1x the median wage rate. The migrant worker will also need to have at least 5 years of directly relevant work experience, with at least 2 years gained in New Zealand that is paid at or above 1.1x median wage rate. In terms of breaking down the 5 years of directly relevant work experience, 3 years can be from offshore, and 2 years must be from in New Zealand. Now, in addition, as additional requirements that apply to this pathway, there is a red list and an amber list, and I'll talk more about this on the next slide. But in essence, with roles that are on the amber list, workers will need to be paid more. So they'll need to be paid at least 1.2 times median wage rate for the 2 years of work experience in New Zealand. Miriam, would you be able to move us to the next slide, please? On this slide, I've just set out the current amber and red list. So the roles listed on the right, red list roles, and for these roles, migrants working in these roles, they are not able to apply for residence under this skilled work experience pathway. Migrant workers working in these roles can still apply, for example, under the current 6-point pathway, but they won't be able to use they won't be able to apply under the skilled work experience pathway. For the roles listed on the left and in the middle, these are amber list roles, and what this means is that for migrant workers working in these roles and looking to apply for residence under the skilled work experience pathway, they'll need to be paid at least 1.2 times the median wage rate for 2 years when they for the 2 years that they need to work in New Zealand. Now, with the amber and red list roles, our understanding is that this will be reviewed annually, and the sort of theory or the rationale between these roles being listed is immigration keeps a list of roles that are where workers are sort of more vulnerable, or where they've seen migrant exploitation occur more often, and the idea and rationale but with the introduction of the amber and red list is for immigration to set a higher sort of requirement or limit or try to mitigate the risk of migrant exploitation via the introduction of these two roles. For the migrant workers that are looking to apply for residence, it just means that there are higher thresholds to apply under when they work in these roles, or they'll need to look for options under different occupations. Miriam, could you help with moving us along to the next slide, please? So in addition to the introduction of the skilled work experience pathway and the trade and technicians pathway, there'll be several changes to the current 6-point pathway. So starting off with the changes to the qualifications that can be used and counted towards points. So in essence, there's been some changes to where the sort of qualifications have been um, um, uh, uh, provided additional points. So for example, for bachelor's qualifications that were not gained in New Zealand, currently they can only be awarded 3 points, but under the new changes after August, the 24th of August, migrant workers can claim an additional point or 4 points. And in essence, what this means is that migrant workers will be able to claim more points and apply more quickly under the current skilled 6-point skilled migrant category for residents, especially when we combine these changes with the work experience changes. Now, things to bear in mind with the increased points are that there has been introduction to require bachelor's qualifications to be held by migrant workers as well under certain circumstances to be able to claim the higher points. So, for example, a migrant worker with a New Zealand master's qualification that is, let's say, for example, gained outside of New Zealand will need to also provide evidence that they hold a bachelor's qualification, so that to be able to claim that additional 5 points for having a master's qualification gains outside of New Zealand. So that's a bit of a change to the current policy. And so if you have any migrant workers that are looking to apply for residence under the skilled migrant category 6-point sort of category, just if they need help and let's say they've got a master's qualification, just maybe indicate to them that they might need to have a bachelor's qualification as well if they want to claim the additional sort of points. Miriam, would you be able to move us along to the next slide, please? In addition to increasing the points for some of the qualifications under the 6-point skilled migrant category, Immigration New Zealand have also increased the points that can be claimed for relevant work experience. Now, under the 6-point skilled migrant category, the work experience is assessed at a lower threshold of just being relevant, which is different to the 2 new pathways, which requires directly relevant work experience. So if you've got any migrant workers looking to apply for residence, it'll be helpful to keep that in mind. But in essence, to summarize the changes under the 6-point skilled migrant category, Immigration New Zealand have increased the amount of points that can be claimed for skilled work experience in New Zealand. So previously, a skilled migrant needed to work at least 3 years to be able to claim 3 points. After the new changes are incorporated after the 24th of August, to claim 3 points for skilled work experience, a migrant worker would only need to work for 2 years. So to, in essence, wrap this change up, what the change means is that migrant workers will, in essence, need to work for a shorter period of time in New Zealand to be able to meet residence requirements. Miriam, could you please help move us to the next slide, please? There are a bunch of additional changes that are also coming in under under all of the sort of pathways. The first one is the counting of skilled work experience and how that sort of interplays with the median wage rate. So currently, when a skilled migrant category residence application is submitted, at the point in time the residence application is submitted, the migrant worker needs to be paid the new or current median wage rate. This rule is being changed to allow migrant workers to just claim being paid the skilled median wage rate when their skilled work experience started. So for example, let's say you've got a chef working for you, and they were paid, let's say, $33 an hour from 2024 onwards. Under the current policy, that chef will need to be paid $35 to meet residence requirements. Under this new change in policy, they can continue to meet, as long as they continue to be paid $34, they'll be able to meet residence requirements while being paid the lesser rate of $34. So this will be quite helpful for your migrant workers who don't meet the current skilled median wage rate, but met the skilled median wage rate when they started their work experience. There are a few other changes. I'll just skip through these because we're running out of time. Miriam, if you can just move the slides forward again. To the next slide, please. I'll just jump into the deportation liability changes. And in a sense, this is an important one because it's already come into effect. So as employers, you'll have resident visa holders, holder employees. Now, if these resident visa holder employees get into trouble in terms of having a criminal charge or conviction, what this recent change means is that there's, in essence, there's a higher likelihood or degree of risk with them having deportation liability raised against them. So the prior position was that if a migrant worker obtained a discharge without conviction, Immigration New Zealand wouldn't raise deportation liability against them. But with the recent change from 27 May 2026 onwards, this relevant provision was amended to capture scenarios where migrant resident visa holders pled guilty or were found guilty of an offence. And so what this means is that even if a migrant resident visa holder gets a discharge without conviction, they'll still have deportation liability raised against them. So if you do have any resident visa holder workers that have the secure, just keep this information in mind. If you need any help, please feel free to reach out. Moving along, Miriam, would you be able to move the slide on? Thanks. There are also some changes under the Immigration Enhanced Risk Management Amendment Bill that haven't come into effect yet, but will likely to come into effect. And this also falls in the deportation liability space. And what this means is that for lower level offending, the period for which deportation liability could be triggered is being increased for 2 to 5 years. For more serious offending, it's the period is increasing from 10 to 20 years, and for very serious offendings, there isn't going to be a time frame that bars deportation liability from being raised. In addition, under the Immigration Enhanced Risk Management Bill, there are going to be 2 new infringement offences that are going to be introduced, and that's, in essence, that's going to capture employers that provide false or incomplete information to Immigration New Zealand. Miriam, would you be able to move the slides along, please? And I've got some information here on those changes for employers, and also, in addition, the time bar for Immigration EMB to raise infringement offences is going to be extended from 90 days to 240 days. And what that means is that if you find a breach, currently Immigration has, in essence, 90 days to sort of ping you for that breach, but that time period will be extended to 270 days. Potentially, if this bill comes into effect. Miriam, would you be able to move the slides along, please? And then again, please, if you can move the slider along to the next slide. Yep. So that was a wrap up of the deportation liability changes. I'll just quickly cover the sort of infringement offences that we're still seeing a lot of employers get pinged with, and in essence, what happens with these, Miriam, if you can move us to the next slide, is generally Immigration New Zealand will ping an employer where they identify that a migrant worker generally holding an accrued employer work visa is employed in a manner that's inconsistent with the conditions on the AEWV. And the most common things where we see this get raised is, for example, let's say the AEWV worker has a location condition to work in Auckland, but they've been working in Queenstown, or they're supposed to be paid, let's say, $29.66 per hour, but they've been paid, a little bit less on their payslip for a few pay runs of, let's say, $28 per hour. If this occurs, Immigration has the power to raise an infringement offence. What the consequences of that are potentially a $3,000 fine, revocation of accreditation, along with some other things, including the listing of the employer on a list of a publicly available list of employers who've breached New Zealand's employment and immigration laws. Miriam, would you be able to move us along with the slide, please? Here, if you've what we've had is a lot of success with helping employers who have breached immigration requirements, and what we've recommended here on this slide is just a summary of what we recommend doing. In essence, we recommend that an investigation should be completed. There should be prompt sort of rectification and fixing of the breach, and then disclosure of the breach to Immigration New Zealand at the earliest convenience. Miriam, if you could move us along. And this includes when an infringement offence letter has been raised, and I've just got a template copy of that letter here. Miriam, if you can move us along, please, with the slides. And here's a factual scenario of what had happened, and sort of the steps that we helped this employer with. In essence, what had happened was, as part of a post-accreditation check, Immigration asked for pay slips and other information. The company provided the information to Immigration New Zealand. Immigration reviewed the information and identified a concern because a worker was paid below the rate set out on the AEWV. Immigration later raised an infringement offence, but at the same time and in parallel, we helped the employer with fixing the offence and also disclosing the offending to Immigration New Zealand. While Immigration did serve the employer with an infringement offence, which was quite scary, we were able to have that infringement offence revoked, which was fantastic for that employer, because what it meant was their accreditation was revoked but then reinstated, and they didn't need to pay the fine, and they weren't publicly shamed on a list of employers who are sort of set out as having breached immigration employment requirements. So that was a fantastic result for them. Miriam, would you be able to move the slide along, please? This is sort of the outcome that you want if you do get into trouble in this area, and we do see lots of employers do get trouble into this area, and it's a letter, in essence, revoking an infringement offence. Miriam, I think that will bring me to an end for my slides. Are there any questions, or would you like to take over for this part?
Yeah, great. Thank you, Shush, for that whirlwind tour of what's new in immigration. What absolutely amazes me is how fast this world of immigration always changes, new updates and new information from Immigration New Zealand coming all the time. So great to have you on board, Shush, to be able to get across those. We've only got one question. I'm happy to stay, right? We're on 11:30, but if anyone else wants to quickly pop up a question before we finish this, or need clarification of what Shush has just covered, now's your opportunity to pop into the Q&A button at the top and post your question. And while you're doing that, I'll cover what we've got there so far. So somebody says, what are you hearing from employers about the high earners threshold? Are they proactively engaging in discussions with this cohort to advise of the change in the company's position on whether they're going to keep things as they are, make use of the threshold, negotiate other terms? So this is a really common question that we are getting at the moment. So we've covered very briefly in this seminar, but more in the previous one earlier this year, that in relation to this high earner clause, the way the transition works is if you've hired anyone from when the clause came into effect in February, then those high earner employees do not have the right to bring a personal grievance in relation to any dismissal. The law says that. It applies to new employees from the get-go. What you're going to really want to make sure, though, is when you give your employment agreements to those new high earners, that there isn't anything in those employment agreements that inadvertently are inconsistent with the new law and might bring in some form of right for that employee to challenge any dismissals. So you need to be really careful in respect of your new employees and the employment agreements that you're providing there. Then in relation to your existing employees, there's a year period whereby parties are meant to be coming together, negotiating, and essentially, unless the parties have agreed otherwise, from February next year, existing high earner employees won't have that right to challenge a dismissal, right? But again, if there's anything that's inconsistent in your employment agreement to that might undermine it, then you'll need to be wanting to change that now. The options are with your existing employees is to either agree to have that employee opt back in to the personal grievance regime, agree or if there is no agreement, the default position is that they're out of the personal grievance regime and they don't have a right to challenge a dismissal. Or the third option is to negotiate some other form of terms, and we're assisting currently a lot of employers and employee clients that are coming to us to work through what that negotiation would look like. Commonly, it's a regime that involves some form of exit payment to the employee agreed in advance in exchange for a record of settlement, and sometimes as well a longer notice period, but there are a bunch of different ways to negotiate that. So that kind of gives a little bit more background. To more specifically answer the question though, are employers going to their existing employees to negotiate those terms or advise them of the law change? Our strong recommendation is that you do, because if you're just going to, the new law change, you're not sure if your new employee does or doesn't, and you're sitting silent on that and just hope that the employee isn't going to challenge it and get over the line in February, arguably that's a breach of good faith. And in particular with your senior employees, that's not really a position that you need to be wanting to get into. So you do have this obligation to cooperate, consult, be open and honest with each other. So yes, we do recommend that you advise your current employees that fall within that category of the change, and that you actively engage with them as to what the agreements are going to be going forward, even if that is just presenting them with a new employment agreement that makes it quite clear that the employee will have no PG rights. And then of course, if the employee pushes back on that, that's a matter of negotiation from there. So hopefully that answers the question that was posed there, but feel free to pop up another chat or another question if it doesn't, or contact us directly if you need some further assistance with that. So while I've gone through that, there hasn't been any other additional questions that have popped up. So I just want to thank everyone for attending today. You know where to find us if you do think of any questions after this, and we really appreciate these opportunities to be able to connect in with you and for you to hear from us. So thank you.